Hello. So maybe you or a loved one has a conviction for a drug offense, or perhaps you're facing criminal charges for a drug offense, and you'd like to know if it's going to affect your immigration status, or if you're going to get deported. So this webinar is for you. My name is Jorge Molina. I am an immigration attorney based in DFW and serving clients all over the world. Today, we're going to be talking about drug offenses and how it affects someone's immigration status. So, when it comes to immigration law and drugs or controlled substances, pretty much there's very little patience and forgiveness for drug offenses. But whether you're going to get deported or if you're eligible for a waiver after a drug offense really depends on your immigration status. So, we're going to start with easier cases and then move to the harder cases as we discuss. And then I'm going to give you some examples of how I've seen some cases get approved and what we can do to avoid a drug conviction on your record that would affect your immigration status or your chances of becoming a lawful resident or a United States citizen. Okay, so let's start easy. So it really depends on what your immigration status is to know whether you're going to be deportable or not. So if you're already a lawful permanent resident of the United States, you can be deported from the United States for a drug offense, except for a single conviction of a possession of less than 30 grams of marijuana. If you have a conviction for possession of cocaine, methamphetamine, heroin, or any other drug other than marijuana, you're deportable. Even if it's just a small amount of drugs, it doesn't really matter. And it doesn't really matter if it was a year ago, 20 years ago, just happened, 30 years ago. If it's anything other than less than 30 grams of marijuana, you are deportable. And in the context of lawful permanent residents, right, these are green card holders, I think the more interesting question is whether you're eligible for forgiveness or a waiver if you are facing deportation. So in this context, I've seen routinely that if you only have a charge for possession of a controlled substance other than marijuana, if it's your first offense and you ended up in proceedings for, let's say you traveled outside the United States or something unrelated to that offense, if you're able to show that you have been rehabilitated and you're sincere in your rehabilitation, courts tend to approve those cases. Now, in other circumstances, if, for example, an individual has struggled with drug addiction for many years and has multiple convictions dealing with controlled substances, immigration judges are known for routinely denying these cases, regardless of rehabilitation. So if that's the case, if you have multiple convictions for drug offenses because you struggled with drug addiction in the past, you need to be very careful with your decisions to travel, commit other offenses, because if you end up in immigration proceedings, not only do you need to show rehabilitation, but you're going to show something else. Another reason why an immigration judge would go that extra mile and say, well, we're going to give this person another chance. So, but the key here is rehabilitation, right? And it's not only about going to rehab, but it's showing that a person didn't commit the same offense again, and after going through rehabilitation. So rehabilitation is key, and then if you have multiple drug offenses, it's less likely that the case will be approved, or that you will not be deported. In other circumstances, more serious offenses, for example, if you're convicted of drug trafficking or anything related to drug trafficking, like distribution, for example, even if it's marijuana related, you can be deemed a drug trafficker under the definition of the immigration code and that would be considered an aggravated felony. So if it's an aggravated felony, there's virtually no relief in immigration court as a lawful resident. And if you're lucky, you can perhaps get some form of relief in court showing that you would be eligible for a work permit and that you can be deported, but your immigration status will be removed, so you won't be a green card holder. So controlled substances violations are extremely serious in immigration court, and you're trying to avoid, if you're a green card holder, you're trying to avoid conviction showing that you were in the trade of drugs. So another important consideration, and this will segue to, people who are not green card holders, is that even if you're a green card holder and you have, let's say, a conviction for possession of marijuana or even possession of paraphernalia relating to marijuana, if you traveled outside the United States, they can prevent you from re-entering, and they would put you in removal proceedings. So you're going to have to explain to an immigration judge why you deserve to remain in the United States, right? So pretty much facing deportation as well. So how does this work, right? So not only do controlled substance violations make you deportable, but in other circumstances, they would make a person not allowed to enter the United States what we refer to as inadmissible. So how does this work, right? So for example, you have a conviction for, just paraphernalia. Many years ago, you were with friends smoking marijuana in college, and police came by. They gave you a citation for drug paraphernalia, not even for drug possession. And then you forgot about it. You travel outside the United States. Let's say you go on vacation to Mexico, and then you're stopped at the border. They ask you about it, say, yes, and they decide to put you in immigration proceedings, right? So they're trying to prevent you from returning to the United States. So that's how green card holders tend to end up in immigration proceedings for simple possession of marijuana. Now, the good news is that there's a waiver available if you're in that scenario, but you must show extreme hardship to an immediate relative. So to your parents, spouse, or children. And if you don't have an immediate relative, well, it's going to be extremely difficult for you to get you're not going to be able to get that waiver, right? So you need to be very careful after getting a drug conviction if you're a green card holder and you want to travel, right? So my advice, generally speaking, is do not travel. And if you do have a drug conviction from many years ago, especially just for simple possession of marijuana, it would be a good idea to apply for citizenship before you and get your citizenship before you travel abroad. Now, regarding applying for citizenship, now if a person is convicted or is engaged in something that's relating to drug trafficking, by definition, you would lack the good moral character required to become a naturalized U.S. citizen. So, for example, let's say you live in a state like California, Washington, Colorado, where the marijuana trade is lawful. Let's say you have a mom and pop shop and you run the store, or perhaps you're a clerk in the store. And then it comes out that you're a green card holder and you would like to become a U.S. citizen. Well, they're going to ask you, well, have you ever been engaged in the trade or controlled substances, right? So while it's legal at the state level, it remains illegal at the federal level. And when you're selling marijuana to a public, that is a controlled substance violation, and it can be considered trafficking. So in those circumstances, you would also be ineligible for becoming a U.S. citizen, even without a conviction. So you need to be very careful with the sort of activities that you're engaging in, especially even if it's lawful in the state that you live. But more now going into the more difficult realms of possibilities. Now the question is, well, if you're in any other status in the United States, let's say you're a student, you are undocumented, or something like that, and then you like to get a green card. Now, if you're undocumented and you have a conviction for any controlled substance other than simple possession of marijuana or anything or relating to simple possession of marijuana, you cannot get a green card. If you have a possession of cocaine offense, even if you're married to a United States citizen and you have a lawful admissions to the United States, you can't get a green card, even if it was 20, 30 years ago. But let's say, you're a student in lawful status and you made the same mistake that a lawful permanent resident does, right? You're charged with possession of marijuana of under 30 grams. Well, if you married a United States citizen, you would be allowed to apply for a green card, but you're going to have to get a waiver. And then that waiver, you're going to have to show extreme hardship to your spouse for you to be able to get that green card. So again, it's very serious. You need to be very careful before you file for a green card if this is your circumstance. It's not only whether you're convicted of possession, anything relating to a controlled substance can be considered a controlled substance violation. And then it is up to you to show that you're still eligible, not only for the green card, but for the waiver. So my advice is don't do bad things, but if you make a mistake, before you plea, before you accept responsibility, talk to an immigration attorney and make sure that your plea won't affect your status in the future or your ability of getting a green card or becoming a United States citizen. On the other hand, if you're undocumented, pretty much if you have a controlled substance violation, even simple possession of marijuana, you have pretty much no relief or defense in immigration court. And very likely, you're going to have to leave the United States. So my advice in those scenarios is just avoid any drug conviction. And then if you cannot avoid a drug conviction, be aware that this could lead to deportations. So folks, I hope you find this information useful. Again, my name is Jorge Molina. I am an immigration attorney based in DFW, but serving clients all over the world. If you have any more questions about drug possession or the effects of immigration in the immigration context, or if you have any other questions, feel free to reach out at info@jmolina.law. Again, info@jmolina.law. Or you can call our office at 469-708-5800. Thank you.